Hi, everybody. Happy New Year. It's nice to be here with you again today. It was a heavy presentation to prepare for estate planning for the new year and the new president, given the actions that were taken in Washington, D.C. yesterday. But what I'm going to attempt to do today is really focus on the legal aspects of all of this and what we can anticipate and what you can do as things may be changing. What I want to really focus on and really have you realize for yourself is that the way our government is set up is that some of the issues that we're going to talk about today are on a federal level. Some are on a state level where we have our own challenges. And a lot of what we're going to be talking about today are things that we are anticipating may happen, but we don't yet know that these things are actually going to happen. And so the only thing we can do is keep our own estate planning in mind, be in touch with your advisors, your financial advisor, your accountants, your lawyers, and make sure that if there are changes that are implemented or that seem like they're really taking hold, that you're in a position where you can make changes that might be beneficial to you and to those that you're leaving assets behind to. So all that being said, let's kick off our conversation about estate planning for the new year and a new president. So we do have a new Democratic president coming into office on January 22nd, President Joe Biden, and Kamala Harris, his vice president. After the runoff elections this week, we have the Senate split at 50-50, and we have the House in Democratic control. I hope, and I think that we saw some of this last night on TV, if you were watching, that there'll be some bipartisan efforts coming down the line to really make sure that whatever we do in our country to fix and deal with the pandemic and the impact that that has had on us, that the two sides are going to be working together to figure out what's best. But some of the issues, since we're talking about a new Democratic control, I want to talk about some general Democratic Party themes that we have seen and that we can assume we will continue to see be brought into the proposals of the democratically led government. Some of these themes are additional payroll taxes on high earners, increased income taxes on high income individuals, increased capital gains rates imposed on high income individuals, taxing the wealthy generally. There are ideas about an annual wealth tax or larger estate or gift taxes, and also an increase of the corporate income tax rate. And these are all just concepts that can be worked into laws over time, may or may not be, depending on how things are handled. So some general, two main topics that I think most affect estate planning and the work that we do with our clients are a change in the capital gains tax regime and a change in the estate tax regime. And so we're going to focus our efforts on those two main topics today. I'm going to start with capital gains tax. So just as a refresher for people about what we're talking about when we're talking about a capital gains tax, we're talking about a type of income tax when an item or an asset is sold and there was a large gain in value of that item from when the individual had purchased it. So I'm going to give an example of an Apple stock. I don't know why I always use Apple stock, but it seems like one that we know has gone up, and it's one that we want to be dealing, that we have a lot of clients who own Apple stock. So let's say somebody bought Apple stock at $1. They bought a long time ago. It was worth $1 when they purchased it. I know this probably isn't true, but we'll make this up for our example. Right before I got on today, I looked, and Apple stock is worth just over $130 right now. So if you purchased it at $1 and now it's worth $130, and you turned around and sold it today, your gain would be $129, and there would be a tax owed at when you paid your 2021 taxes, because you were doing it today, on the income that you earned off of the sale of that asset that you were holding on to. So that's what a capital gains tax is. This also applies most often with people who have real estate that has gained in value. So take the person with property maybe on the east end of Long Island, or perhaps in Brooklyn or Queens or some other area that they purchased back in the 60s or the 70s for $10,000 or $20,000, and now it's worth $1 million. Well, the amount that has grown, when they sell that asset, they will pay a capital gains tax on the value of the gain. Now, there's certain, when we start to talk about property, you can take off, there are exemptions for it being a primary residence and things like that, but that can be a large tax on someone. So what we have a lot of times are clients who say, you know what, I would sell my house and I would downsize, but the capital gains tax is going to be so enormous, I'd rather wait. And when I die, my family that I'm leaving my house to will get a step up in basis at my death, and then they won't owe this tax. So what are they talking about? What they're talking about is that our current laws say that at someone's date of death, these assets get a step up in basis. And so when they're sold at the date of death value. So if I own my home that I purchased for $10,000, and when I die, it's worth $1 million, if it's appraised at $1 million on the date of my death and my family members turn around and sell it for $1 million, well, then there's no gain and there's no tax, as opposed to the tax they would have paid, or I would have paid, if I had sold it during my lifetime and had to pay that gain. The same will go for that Apple stock. If it's worth $130 on my date of death, then when my executor or my trustee or whoever's in charge of my estate sells that stock, they're going to be selling it with the cost basis of my date of death value, not the $1 value from when I purchased it. So that's what capital gains is, and that's what the current law is. Some of the proposals that we saw during the election season, and some of the things that may be brought up as they're possibly coming up with ways to raise money for the government, is that they could increase the percentage of the capital gains tax. So they can make it a larger high level. It's a sliding scale of how much tax you pay based on how large the gain is, and they can make the tax a larger percentage of the gain. That's one thing they could do. Another thing that was discussed was an elimination of the step up in basis. So that's going to mean that if I die and my house is worth that $1 million, even if I leave it to my heirs after my death, they're going to be stuck with that same capital gains tax that I was stuck with, because they're not going to get that step up to my date of death value. So they're still going to be paying capital gains tax on my original purchase price, that $10,000 or $20,000 that I purchased the house at. And so that elimination of the step up is going to change for some people, or it's going to change how some people act. They may not hold on to those, what we call low basis assets, those assets they bought for a very little amount that have gained in value so much. They may not hold on to them until death, where they were waiting for them to get that step up. They may decide not to do that. They may change their plan. But it's important to note that none of this, like any estate planning, is one size fits all. Because while I may not be selling my home because I want the step up in basis, but I would otherwise have downsized and moved to a condo long ago, my neighbor may say, I don't care what happens. I don't care what the taxes are. I'm not leaving my house until they take me out after I die. And for that person, that might not change their estate plan. So again, you really need to look at what these potentials are and how they may affect your plan. And the answer may be, after analysis, that there's no difference in the planning that you're doing. So in terms of the big changes for estate planning when it comes to a capital gains tax change is, like I said, some people may decide to sell assets differently. There's certain other charitable trusts that can be created if somebody's charitably inclined to deal with a low basis asset, if it's not going to get that step up because the charity won't pay the taxes and you could get an income on it for your lifetime. There's a lot of different planning that can be done, and this is where you really need to take this information and talk to your own advisors and figure out what you might want to do to fit your own goals and be as tax efficient as possible. The next thing I'm going to discuss is a potential increase in the federal estate taxes owed after someone's death. Now, I'll go through what the current law is, and I'll go through what some potential changes could be. So we're talking about a new administration, so we're mostly talking about federal issues here, but I am going to go through what the New York State estate tax rules are as well, just so everybody has an understanding of how estate taxes work after someone's death. So currently for 2020 in New York State, if you have less than $5.93 million when you die, there is no estate tax. So if I die, and when you add up all my assets, it's only worth $4 million, there will be no tax on my estate. However, once you go over that 5.93 million by 105%, there's what we call a cliff in New York State. And so I describe it like this. You go no tax, no tax, no tax. You hit 5.93. Once you hit 5.93, there is a tax. But once you hit 105% of the 5.93, you fall off the cliff and you're taxed back from $1. So you're not just taxed on 5.93 to what your estate is, you're taxed all the way from the bottom. And so that can create an enormous tax. You can take somebody who had an estate in 2020, it was a $5.85 million exemption. It's gone up a little bit in the new year because of inflation. But in 2020, if somebody that you know died in 2020 and they had just over 5.85 million, if they were $100 over, they would have owed $223 in tax. Now, if you take that same person and you put them at the 105% level, they would owe almost $530,000 in tax. And so you can see that that cliff can make a very big difference in the estate taxes that are owed. And so there's certain tools that we use to help clients deal with the fact that they don't know exactly what the exemption is going to be when they die, and they don't know exactly what their asset value is going to be when they die. And so sometimes we want to disclaim certain assets to charity to get back underneath the exemption level. And so that's something you're going to want to look into if you think you might be nearing that exemption level or nearing that cliff. Now, on the federal, I should also add that in New York State, there is no gift tax. And as long as you give a gift and you live 3 years beyond that gift, it's not added to your estate. So if I give away $3 million and I live more than 3 years after I've given that gift, then that $3 million is as if it never existed in terms of New York State estate taxes. And so if I die and I only have $2 million left, there's not going to be any issue because that 3 isn't going to be added on to my estate. Now, in the federal government, things are handled a little bit differently. And this is where we could potentially see some changes based on this change in administration. So in 2021, the federal exemption is $11.7 million. So it's quite a bit higher than the New York State. And that is because the current law, the Tax Cuts and Jobs Act that was signed while President Trump was in office, stated that the exemption would go up and would sunset back to 5 million indexed for inflation in 2026. So this 11.7 million is our 2021 number. I can anticipate it will go up incrementally in 2022. etc., until we hit 2026, in which case it will revert back and probably be right about where the New York State is at around 6 million. And so the federal government has a much higher exemption right now. So what that means is that most people are not paying state taxes because each spouse, in fact, has $11.7 million exemption this year. That means as a couple, you could give over $22 million, over $23 million, and not have any estate taxes on the federal level. Now, in the federal government, They tax on the amount that you're over the exemption. There isn't that cliff. And there's also a gift tax on the federal level. So in my example, where in New York State, I gave $3 million and I lived 3 years beyond that $3 million, that is not part of my estate. That's not so for the federal government. So if I give away $3 million while I'm alive, and then I still have $9 million in my name when I die, my total estate that's going to be taxable is going to be the 9 plus the 3. It's not just going to be what I had in my name when I died. And so that's why people file gift tax returns when gifts are made during life. It's as a placeholder as against that lifetime exemption. If you are someone who believes that you may have a federal taxable estate, then you want to think about what assets you're giving away, if you're giving them to an individual, if you're giving them to a trust, and how to decrease what your overall taxable estate is going to be, because you have only that exemption in life and in death. And so there's going to be planning that you're going to want to do if you want to, again, be tax efficient. So what can we do? We do different planning in terms of assets going into trusts, giving gifts during life, giving gifts maybe right now while the exemptions are high before they go back down. And these are things that, again, if you are in that realm of person who is over the 6 million, and certainly if you're over the 11 million, you're going to want to be discussing with your advisors how to be tax efficient upon your death with your estate assets. And any planning that you have, you're going to want to have it reviewed, because even if this new administration doesn't make any changes, we know that with the current law, it will sunset in 2026, and that exemption level is going to go down again. Now, some of the changes that we can anticipate may happen is that they could raise the percentage of estate tax that is charged on the federal level. So if the highest estate tax rate right now is 40%, that could go up. And in our history of our country, it has gone up. It has gone up to 70%. And so that is something that could go up, because the idea being that those that are dying with a very high amount of assets in their estate will pay a high percentage on the transfer of that wealth. And so that's something to watch for. Something else to watch for is going to be a lowering of that exemption prior to the sunset. So one thing that has been proposed again during election season was that perhaps the estate tax exemption, rather than being this 11 million or the 5 million index for inflation, that be 3.5 million, for example, or lower. And it's unclear what will happen or if that will happen, but it's certainly something that's been suggested, and it's something you should be watching for to see if there are any changes that you need to make as a result of that change with your estate plan. Beyond the changes to the administration, which we've also seen in 2020 a bunch of changes on the legislative side, both federally on a state level, that is going to possibly change the planning that you want to make sure is done for you and for your heirs and the loved ones that you're leaving assets to. We had the Secure Act, which was signed in December of 2019, which went into effect in 2020, which changes the rules for retirement accounts. It makes the age at which you have to take your required minimum distributions later. It's now 72 instead of 70 and a half. But it also makes it so that when you're leaving these retirement accounts, these tax-deferred retirement accounts, IRAs, 401ks, 403bs, 457 plans, all of these tax-deferred retirement accounts, when they are left to beneficiaries other than your spouse and a few other certain people who get special treatment, there's a forced 10-year payout now. So it used to be that if I left my $500,000 IRA to my daughter could take a stretch over her life expectancy and take very small distributions because she had a long life expectancy because she was young. She now is forced to take a 10-year payout. And so that's in the course of 10 years, that's $500,000 more taxable income than it was if she had to take a stretch out, and more income than she's receiving from her salary or whatever income she herself is generating, which was going to result in a greater tax. And so that's something you want to be aware of and thinking about with your planning if you are leaving retirement accounts behind to beneficiaries. Again, there may not be an actual change that you decide to make, but you should figure out how the Secure Act is going to affect you and your beneficiaries and see if there's anything that can be done to minimize those taxes. Then decide if you want to take those steps, if they're going to fit in with your own goals of your estate planning. Another big change that we saw on the state level was that there was a big change to the Medicaid program for home care services. And every year in the governor's budget, there are changes which amount to cuts to the Medicaid program and additional barriers to eligibility. And the one that was most significantly added this year on a financial level is that there's now a 2.5-year look back for eligibility for home care services and community-based services. And so for those who are looking to do planning to transfer assets and then eventually apply for Medicaid for home care services, you're going to want to be aware of this new look back and decide if there's any additional planning that you should do now. The other big change legislatively, which was signed in December of 2020, is that New York State has amended the General Obligations Law, which is the law that governs our power of attorney. The power of attorney statute was amended to make certain changes to the power of attorney document, the requirements of signing. And so you're going to want to look into your own document and just check in with your attorney and see if there's any change, any additional things you need to be doing in terms of your power of attorney document. We plan as a firm to be doing webinars in the coming weeks, which we haven't yet posted, on an update on these Medicaid changes, because that's an ever-evolving situation, as well as the new power of attorney laws. So keep a lookout for those and stay tuned for them. Especially with the Medicaid, there's going to be a constant change. So while we have put out information in the past, since April, when the budget was signed and these new laws were enacted regarding the Medicaid changes, because of COVID and because of the federal money that comes in from stimulus packages for COVID and the state of emergency that the state and the government are in because of COVID, it is changing the implementation date on some of those Medicaid items. And so we're going to update you on that. Even with the power of attorney law, we have a reason to believe that while it is coming into, it has been signed into law and is in effect, that there are going to possibly be some small amendments to the signed law and the changes that were made to adjust for some last minute advocacy that was going on. And so we will keep you posted on all of that. And again, keep checking back for when we are going to be doing those. So in sum, what can you do? What can you do now? I talked about a few different specific things that could be done in terms of maybe putting assets in a trust, doing some additional planning, getting rid of lower base assets if we're worried about a loss in the capital gains step up. These are the details you can do, but really what you should be doing is checking in with your advisors, financial advisor, accountant, lawyer, anyone else that you seek advice from in determining what to do with your assets and how to protect you and your beneficiaries. You're going to want to check in and keep these relationships going because this is an ever-changing situation in terms of the laws and on the federal level as well as the state level. And you're going to want to make sure that your estate planning is up to date. Estate planning is not a one and done situation. It's something that requires a review to make sure that as the laws change and as you change and as your goals change, that your estate planning evolves with that as well. And so people always ask me, how often should you be reviewing your estate planning? And I used to say every 5 years. And then I added to that every 5 years and when there's a major change in your life, a birth, a death, a retirement, selling your home, anything, any big change like that. I will now add to that you certainly need to continue reviewing your estate planning based on changes to the government structure based on changing an administration, a change of an actual law, or a concern about a potential change in law. And so I think that 5 years should really be a lot shorter of a time frame now. Perhaps on an annual basis, certainly you should be checking in to make sure with your advisors that there aren't things that you're missing that need to be done with your estate plan. So I thank you for listening today. I'm going to answer, I see there's some questions that have come in. And again, for anybody who has to sign off, I hope that you have a very happy, healthy, and prosperous new year.
Thank you. Okay, first question. I bought with my husband a property in 1999 for $251,000. Now that my husband died in 2020, I am selling it for $2.3. Do I have to pay capital gain tax for the full amount?
So my short answer is you should be speaking with your accountant about exactly what the capital gains tax will be and how the property sale will be taxed. But I will say that when there are joint owners on a property, the joint owner who dies owning a property, their half of the property will get a step up in cost basis to their date of death value. And so it is unlikely that you'll have to pay capital gains tax for the full amount given the information that was given here. But I would certainly recommend that you check in with an accountant to determine exactly how to minimize the tax that is owed on the sale. I see that there's a question here regarding U.S. citizenship and international. It's funny, we got a question on the international estate tax planning last time, and I'm going to leave that question aside, and you can email us separately. But our firm and me specifically, I don't practice often in the international estate tax regime, so I can certainly refer that person out to someone who could be more helpful.
Thank you, Britt. Next question, is it a good idea to buy shares RETS 1031 and save the taxes for now? I would defer that to a financial advisor. I'm deferring a lot today, but that's really a question for a financial advisor, and that's really how to invest your assets is really going to be very individualized based on what you have and what you need and what your income is. And so I would speak to an advisor about that. Thank you. Next question, what about conversion from IRAs to Roth? What are the pros and cons for heirs for a senior person?
So, when you're converting an IRA, a traditional IRA, to be a Roth IRA, you are taking a completely tax-deferred asset and you are moving it into a Roth IRA and you're paying the taxes. And so again, this is going to be a question that is going to be relevant for a financial advisor to discuss with you as to the benefit, whether or not that should be done. But I think the benefits for the heirs are certainly that they now don't have to worry about having a 10-year payout and having accelerated income taxes on those assets because they're not inheriting a fully tax-deferred asset. For the senior person, the con is certainly that you're paying the taxes while you're alive. And that's really the biggest con. But every family structure is different. And so you should really be taking into account what the senior's income is and what tax bracket they're in, what the heirs, what tax bracket they're in and what income they have coming in. And then I'm sure there's plenty of other factors that a financial advisor would discuss with you to making sure you're being most tax efficient for yourself and if it's important to you for your family as well.
Thank you, Britt. Next question. Is there an advantage to having a revocable or irrevocable trust to avoid probate delays?
There's certainly an advantage to having a trust of either type to avoid probate delays. I think one of the things we learned in COVID is that courts can shut down. And this was not something we thought about, but they certainly can. They can have delays. And depending on the personal structure of your family, probate can really be a nightmare. If you're disinheriting one of your official next of kin, probate can take a very long time and can be very contested. If you don't have easily recognizable heirs, if you're a person who's not married, no children, only child, you don't know where your cousins are, probate could really be very difficult because it requires that your next of kin be determined who they are and that they be notified. And after a very lengthy process, if you can't notify them and you prove it to the court, or those that you've left behind to probate your will, prove to the court that they can't find who those heirs are, there are certain things that need to be done, but it's a very lengthy and can be a very expensive process. So avoiding probate with the use of a trust is certainly advisable in many situations.
Thank you. Is there an optimum time of year to check in with my attorney? In what order should I consult these advisors?
That's a good question. There's not a necessary time of the year that's important. I mean, right now it's January, so some people think, okay, this is gonna be something I do at the beginning of the year. Some people say this is something I'm gonna do on my birthday, or this is something I'm gonna do at the end of the year. So I don't think there's particularly a good time of year. I mean, I think if you haven't checked in with your advisors in a while, now is a good time, because there are, especially with the change in the power of attorney law, which was just signed last month, and the changing, if Medicaid is on your radar, you're going to want to get that information sooner rather than later. But I would say there's not a specific time of the year that is generally better than others. In terms of the order in which to check in with those advisors, there's not really an order. I mean, most financial advisors are checking in annually with their clients. Most people have the annual check-in with their accountant because they're filing their taxes. So a lot of times it's really just the lawyer that's kind of out of that loop. And so I would say they always fall third for some reason after the financial advisor and the accountant. But there's not a particular order that's required. And it will often require a conversation between those three individuals or some version of them to see if there can be a team approach to come up with the best plan for you.
Thank you. In the Secure Act, Roth are still not taxable. Is this correct?
The Secure Act did not make any changes to the Roth IRA, or there are no changes made to that. The only change is on the payout of the any tax deferred money.
Perfect, thank you. Are repairs and additions on your home go against the valuation of your home?
Yes, so when I briefly glossed over, I should say this, so I will explain in further detail. So if you purchase that property, as I said, for $10,000, and it's worth $1 million and you're selling it, and it's your primary residence for 2 of the 5 years prior to sale, then your basis that taxes will be based off of is the $10,000 that you purchased it at, plus a $250,000 exemption for being your primary residence, $500,000 if you're a couple, plus any capital improvements. And so if you've improved your home, that will all go into it. So if you've got the $10,000, say it's an individual selling the home, then it's $250,000. So now you're at $260,000, and they can show that they put $100,000 into the property. It's now at $360,000. The capital gains tax will be calculated based on the difference between the $360,000 basis and the $1 million sale price.
Thank you. Please explain again the over 105% on New York State estate tax.
Right. So the cliff is what you're referring to here. So what the cliff says is that if your estate is 105% over the New York State exemption, then there is a cliff. And so that means you're paying back from $1. So my example that I used was off of the 2020 numbers for those dealing with estates for someone who died within the last 12 months. So if the exemption was $5.85 million in 2020, 105% of that is $6,142,500. So if your estate is at $6,142,501, $1 over that 105%, over that cliff, then the estate tax owed is 528 and change, 528,000. And so you can see, because you're taxed back from $1, you end up with a tax that's quite large. Whereas, and in a lot of people's situations, we put a disclaimer to charity in, which is if you gave away to charity, the difference between that 5%, between the 5.85 million and the amount that you're over, that might very well be less than the 528,000. And then that money is going to a charity. It takes it out of your taxable estate. You're back underneath the exemption level, and less money went from your estate, and instead of to taxes, it went to a charity. And so many people are trying to avoid falling off of New York's cliff to avoid that larger tax that's going back from $1.
Thank you. In order to avoid the state tax on distribution of IRA account, to which state can you move?
So I'm only licensed in New York State, so I can't give advice on any other, but a distribution of a retirement account is an income taxable distribution. So you'd want to be looking into places that do not have an income tax. But that is something that is incredibly state specific.
Thank you. Next question. Do the capital gains apply to condos, co-ops?
They do. They apply to condos, co-ops, residences, stocks, as I said, applies to all of those.
Perfect. That's it for our questions.
Okay.
It looks like we have one more.
Okay.
What are the chances that New York State estate tax will be raised or lowered?
I left my crystal ball at home today, but I think that I can't even begin to guess. I can tell you that our estate tax in New York used to be at 1 million, and the law was changed that it slowly graduated up to where it is now, and we are now at 5 million index for inflation. So it could always go up. You know, New York State is in a budgetary crisis, just like many other places and like the federal government. And so it's certainly possible that it could. I have not seen that discussed anywhere, but I also didn't see discussed many places putting a look back on home care Medicaid, and that happened. So I have no way of knowing if that's a possibility. Thank you, everyone. Have a good day.